Thank you, Maggie, and thank you to Savvy Ladies for having me here today. So as you know by the title, we're going to talk today about 5 common estate planning mistakes made by women and how to avoid them. So just let me start by saying you don't have to be a woman to take away from what I'm talking about today. It applies to everyone. Additionally, if you are not a female, you definitely have someone in your life that this will apply to. So whether it's you yourself, a client, a loved one, there's definitely some takeaways for everyone. So let's just jump right in. So let's turn the page, just a second, guys. I apologize. Okay, so now let's jump right in. The first and most common mistake is not having an estate plan. Not surprising because most people don't even know what an estate plan is. So what is an estate plan? It's the process of managing your affairs, your assets for while you're alive and when you're deceased, as well as if you're disabled or you have long-term care concerns. So it's the process of having all of your affairs in order. And I like to think of it as a toolbox. So most people as a homeowner have a toolbox and then they have their screwdriver maybe in there, they have a flashlight. I'm not much of a tool user, so I'm not quite sure what other tools you may have in there, maybe a saw of some sorts, a hammer, nails. I like to think of an estate plan in the same vein, an estate planning toolbox. What do I need to have in that toolbox? I need to have my advanced directives, a will, maybe a trust if it applies, a prepaid funeral plan, and an appointment of the agent to control the disposition of remains. So let's really just break this down. So what are advanced directives? Advanced directives actually take care of planning for while you're alive. So that includes your healthcare proxy, your living will, your power of attorney, which I'll get to on some later slides, but that's planning for while you're alive. Then obviously people have heard of a will, right? I need a will in my estate plan toolbox. What is a will? The will disposes of any assets in my name at my death. So we'll get into that also on a later slide, but that's something I want in my toolbox. Now, I may want a trust in my toolbox. There are certain circumstances where I would want to trust, maybe some that I would not want to trust. So some reasons why I would want to trust in my toolbox, I'll get into later, but I'll go over briefly now. Maybe I have concerns about estate tax planning. Maybe I have concerns about long-term care planning. Maybe I'm worried about family fights and I don't want anyone to fight. So I put it in a trust and I don't have to worry so much about fights, but that will also go in my estate plan toolbox if applicable. And then another less common known about tool for my estate planning toolbox is a prepaid funeral plan or an appointment of agent to control the disposition of remains. So people often will tell me, oh, I have this already. What they really mean is they have a burial plot. So there are 2 kinds of pieces to this. There's a burial plot, which is where your body will live for eternity. And then there's the funeral that gets you from being deceased to the actual burial plot. So there's a prepaid funeral plan, or that means you go into a funeral home rather, and you speak to a funeral home and you say, this is the funeral I want to have, and you pay for it now, and it's taken care of later when you're deceased. Nobody has to think about it. Or if you don't want to go into a funeral home now, you can do what's called the appointment of agent to control the disposition of remains. And basically, it appoints somebody in charge to make those end of your body decisions, what happens to your body after you're deceased. So for example, I'll have a client that says to me, I come from a very religious home and they do not believe in cremation. They want everybody to be buried, but I really want to be cremated. I will then have that client either prepay their funeral plan because I want to make sure that's what happens, that their wishes are followed through with, or I have them appoint somebody who is going to follow through on their wishes to be cremated so that at the time of that individual's death, there's no fight over what did Karen want, what did Karen not want. We don't agree with what Karen wanted. Well, too bad, because Karen appointed Jane Doe to take care of appointing her disposition of remains and making sure that she's cremated. So that's something that most people don't think about. Another pointer here is advanced directives, which I will, like I said, get into on later slides. I do want to point out as follows. When you are age 18, you are now considered an adult. Even 18-year-olds need their toolbox in place. So whether it's somebody who just graduated high school and they're 18 and they're going off to college, they'll need to have some tools in their estate plan toolbox. Whether it's somebody who's 99 and has a more complicated concern, well, they'll have different tools in their toolbox, but they'll still have a toolbox. So the first strategy to avoid not having an estate plan is to take that first step, right? Speak to somebody, whether it's an attorney, whether it's doing some research on your own, whether it's reaching out to somebody in your network of a financial advisor, perhaps, or a wealth manager or an insurance individual. These are people you want to reach out to and start getting your ducks in a row. At a very minimum, I always recommend put it on your to-do list, because then it's never going to go away. It's always going to nag you. So these are important tools to have, whether you're fine and healthy, whether you have assets, whether you don't have assets. You want to make sure that you put these things into place. That's number one. Let's move on to number two. Not planning for while you're alive. So a common misnomer is estate planning only matters when I'm not here. Well, like I just said on the previous slide, estate planning is actually for while you're alive as well, right? I need to know what's going to happen in the event of my incapacity, in the event I become temporarily disabled, permanently disabled. What happens? Who makes decisions for me? So not planning for while you're alive is a common mistake. This is the piece of the estate planning toolbox, which I'll constantly refer to while you're alive. This is the tools on the advanced directives. So what do I typically have as a tool for advanced directives in my toolbox? I'll touch on the power of attorney, the healthcare proxy, the living will, and then we'll get to two kinds of insurance that I just want to raise your attention to. Even though it's second, I'm going to start with the healthcare proxy. So what is a healthcare proxy? A healthcare proxy is a document in which you appoint somebody to make a healthcare decision for you if you couldn't make one for yourself. So if I can make a healthcare decision for myself, it is 100% my decision to make. Nobody gets to make that decision for me. I get to decide. However, if I am incapacitated now, whether that's temporary or permanent, I appoint somebody to make a healthcare decision for me. So a typical example I will use is as follows. If I'm in a car accident and I'm taken to the hospital unconscious and I have a broken nose, and the ER doctor starts to fix my nose, my healthcare agent can run in and say, hey, ER doctor, stop fixing Karen's nose, go get a plastic surgeon. They now have to listen to my healthcare agent. Alternatively, I can wake up out of whatever unconscious state I'm in and say, hey, ER doctor, I know my agent said to go get a plastic surgeon, but I really don't care, fix my nose. They have to listen to me. So to that end, it springs into effect and it springs out of effect based on my capacity. I also have the opportunity to make health organ donations on my healthcare proxy. I can have that listed on my healthcare proxy. If it is on my healthcare proxy, I definitely want to make sure my driver's license on the back also signifies the same thing. So I don't want them to be conflicting. I won't get into too much more detail on the healthcare proxy, other than to say you must have a conversation with your healthcare agent what you would want in the event you cannot make a decision for yourself, right? I can't appoint Maggie to make a healthcare decision for me if she has no idea what I want, because I wouldn't know that my wishes would be carried out. That would make me uncomfortable. And Maggie would have no idea in making that decision what my wishes were. So that would make her uncomfortable. So we need to be on the same page. You need to have these hard conversations now as to what you would want in the event you couldn't make a decision for yourself. The living will actually goes along with the healthcare proxy, and it applies to end of life decisions. So your healthcare proxy makes everyday healthcare decisions for you if you couldn't make one for yourself. The living will allows your healthcare agent to make end of life decisions for you. So this is not a DNR. A DNR, you walk into a facility and you say, I'm going in for a surgery, DNR. I want a DNR. Or I'm in a specific situation, I want a DNR. A living will allows that agent, if I couldn't make that DNR decision for myself, to make these end of life decisions. It would say something along the lines of, I don't want to be kept on any life extending machines. I want to be kept as comfortable as possible. I don't want to be in a facility. I'd rather be home. Things like that would go in your living will, and they really work hand in hand together, the living will and the healthcare proxy. Again, the healthcare proxy springs into effect. The living will only comes into play in the event there's no hope of me getting better. So it springs into effect upon that situation, upon, for example, me being brain dead, but it won't spring out of effect because then it wouldn't be in effect in the first place. Then we have a power of attorney. So that's another tool I want in my toolbox. So unlike the healthcare proxy that springs into effect and springs out of effect, and unlike the healthcare proxy that only deals with healthcare decisions, the power of attorney only deals with non-healthcare related decisions. So for example, a power of attorney will deal with financial related actions. It will deal with real estate transactions. Anything non-healthcare related goes under the power of attorney tool. Now, the power of attorney is not a springing document generally. So what does that mean? It means that I appoint somebody to handle something non-healthcare related for me, so they could sell my house, they can access my bank accounts at the point of my signing the power of attorney. So it doesn't spring into effect and out of effect. It automatically is in effect once it's signed. So a typical analogy I'll use here is if I have a car and I have a set of keys to my car, I can use the car whenever I want, and I don't need to ask anybody for permission. I can also give a set of keys to Jane Doe and say, hey, Jane, here are my keys to my car. Guess what? Jane can drive the car whenever she wants, also without asking my permission. So I can drive the car whenever I want without asking her. She can drive the car whenever she wants without asking me. The same is true of the power of attorney. I'm giving somebody the keys to my car, which is really anything that I can access non-healthcare related. To that end, it's a very powerful document. I'm giving somebody complete access to anything non-healthcare related. So you may say, well, that's not something I really want to have. So let me tell you some stories and tell you why you do want to have it. If I do not have a power of attorney and I need one, if I do not have a healthcare proxy and I need one. So for example, I'm in that car accident and I'm not getting better and my bills need to be paid. And I was in the middle of selling a property. What happens? Who gets to make these decisions for me? My family now actually needs to go to the Supreme Court and file a guardianship petition to be appointed as my guardian to handle all of my healthcare and financial decisions. So if I don't do these documents proactively, well, then my family is going to have to pay a legal fee to start a action in the Supreme Court. They're going to pay filing fees. And then there's a whole blown court proceeding as to appointing a guardian. So two stories here. One is a matter that happened over COVID. A friend called me. Her parents were in the process of selling a house in New York and purchasing a house in California. Dad went to sleep, suffered a very intense stroke, and now incapacitated. Did not have any ancillary documents in place. What happens? Karen, can you help us? Unfortunately, it's not a quick fix. We have to now go to the Supreme Court, have a court proceeding to have this client's mother appointed as her husband's guardian. Now, that brings up the stress of potentially losing the sale of that house, right? They were selling a house. It potentially loses the purchase because maybe it took too long. It's a 6-week process, whereas had he had a power of attorney, it would have been as simple as giving the parties to the actions powers of attorney and just continuing on the way. So this was a hiccup, a 6-week hiccup in the road. Thankfully, it worked out, but there was obviously potential for it not to have worked out. Another story. So let's say, this is a real story I was involved in. A woman who had 4 daughters was diagnosed with dementia. She did not put her estate planning documents in order. And she had 4 daughters, 3 of whom got along very well, and 1 who was on the outs, I would say somewhat estranged from the family. The 3 daughters got together and said, you know what, let's file a petition for guardianship for mom in the Supreme Court. No problem. We'll request that 1 of the 3 daughters be appointed as mom's guardian. No problem. The 4th daughter, who was estranged from the family, contested that and started spinning everybody's wheels. And so what was supposed to be a quick proceeding, 6 weeks, now actually became a longer process. And there was such a contest amongst the 4 daughters that the judge ended up appointing a family friend as mom's guardian, not one of her daughters. So I could tell you, I'm a mother, I have 3 daughters. I would never want a family friend over one of my daughters to be my guardian. How do I avoid that? By putting these documents in place. So yes, strategy is they're difficult conversations. These are difficult documents to think about, and they are powerful. However, the cost of not having them is so great that it does not outweigh not doing them in the first place. Now let's move to the insurance. So I will just disclaim here that I am not an insurance broker. I'm not an insurance advisor. I speak from my professional experience. What is disability insurance? How am I providing for situations where I can't provide for myself anymore? So this is a good question, and I can't really see your faces or your reactions to this question. But my typical question, if we're in a room, is I will ask you, what is your biggest asset? And I'll get some answers like my house or my life insurance policy. And what I will say to a woman is your biggest asset is your ability to earn income, because that is how you provide yourself. That is your key to independence, to freedom. What happens if you become disabled and you cannot provide for yourself anymore? So the typical example would be a brain surgeon who can no longer use their hands, or any surgeon, or an orthodontist even, right? You can't use your hands anymore. Well, who is going to cover that source of income? Disability insurance. That's what disability insurance is for. If you are a provider for your family, whether you're the sole breadwinner or not, who is going to make sure that income still comes in if something should happen to you? Long-term care insurance. So as the name is, long-term care, it's insurance that provides assistance or insurance should I need long-term care as I age. So it used to be a kind of insurance product where I would pay premiums my whole life. And if I needed long-term care, well, great, because I've paid these premiums my whole life, and now I have this insurance product. Versus if I got hit by the proverbial bus, even if I paid these premiums my whole life and I never needed long-term care, well, then I kind of wasted these premiums because they're going out the window. So that standard long-term care insurance policy, I like to think of as a use it or lose it, right? I either use it during my life for long-term care, or I lost it. I paid all these premiums and I basically threw them in the toilet. That is now becoming like a dinosaur in the insurance world. Now what we have, or what they have in the insurance world, is an insurance policy with a long-term care rider. So what that means is I have a policy, and if I have long-term care needs, I get to access that policy during my life. If I never need long-term care, well, then my beneficiaries get that policy on my death as if it's a straightforward life insurance product. So instead of that use it or lose it type of deal, it's actually a use it or use it type of deal. Now, again, I'm not an insurance advisor, but I do know, as most people can probably deduce on their own, these insurance products are easier to get when you're younger, when you're healthier. I always recommend looking into it. There is no harm in having a conversation. And as women, we have to understand that our life expectancy is longer, and on average, maybe 5 years. If we're the sole breadwinner, how are we providing for our family? If we're not the sole breadwinner, even more so, what happens to the income we're relying on? We need to be able to provide for ourselves should something happen to that person. They're hard decisions, they're hard conversations, but we need to have them now, because if we don't have them now, it will be too late. So this is going to tie into a theme from the first slide, which was not having an estate plan, to being proactive. You must be proactive rather than reactive, right? Those two examples that I gave you with the guardianship, that was a reactive situation. It's much better to be proactive and just have things go seamlessly through. So let's move on to the next slide. So we have done our estate planning for while we're alive, and we thought about all of those things that we need. Now we need to think about the later. What happens when we are no longer here? So most people think they know what happens. How many times am I sitting down with a couple and they'll say, yeah, we're married, we have 3 kids, but it's okay because when I die, everything's just going to go to my husband. I don't really need a will. Well, that's not exactly true. In New York State, if you don't have a will, New York State goes ahead and writes a will for you. And that way that your assets go under New York State's will, called intestacy, may not be the way that you want it to go. So people who think that their assets go to their spouse, that may not be the case. So for example, if I'm just married and I don't have kids, yes, my assets will go to my husband. However, if I am married with kids, well, no, not everything goes to my spouse. My spouse and my children actually have to share that. In addition, the law doesn't care how old my kids are. So if I have a 5-year-old, my 5-year-old is going to be getting assets in her name. And when she's the age of 18, she now gets it. Now, if I don't have significant assets, maybe I don't care if she gets $500 in her name, but maybe I do have significant assets. Maybe she's going to get $500,000 in her name. And that's not something I would want an 18-year-old to have. Additionally, intestacy does not let you choose a guardian of minor children, an executor of your estate. So an executor is the person in charge of collecting your assets and then distributing them. If I go the intestacy route, that's where New York State writes that will for me. I don't get to choose that person. Yes, there's a class of people that it's chosen from, but I don't get to choose. So for example, if I'm just survived by children, my children equally have the right to be what's called the administrator of my estate. They're able to collect the assets of my estate and then distribute it. However, what happens if my children don't agree as to who that person should be? Well, then I didn't get to drive the boat. I didn't get to be proactive, and I'm creating unnecessary conflict. Also, a trustee. So it may be that under my will, I just mentioned a 5-year-old child. Maybe I don't want my 5-year-old inheriting assets, right? Maybe I want it to go to a trust for my child's benefit. Maybe my beneficiary is receiving government programs and I don't want them to be kicked off of their programs, and I want them to get their inheritance in a trust. Making a will allows me to handle that. If I go under the intestacy where I don't have a will, well, I don't get to do this trust, and I don't get to choose a trustee. I don't get to plan for situations such as disability. I don't get to plan for situations such as marital problems or creditor problems, or even if my beneficiary is simply applying for financial aid for one of their children to go to college and may not want additional assets in their name, may be worried about malpractice concerns. I want to put that in a document, in a will, not have New York State's will control that. Additionally, if you have a business, so especially for women-owned businesses, you want to be in charge of the succession plan for that business. And you want to make sure that succession plan for your business is consistent in your operating agreement and in your will. So if you're a business owner and you have a key employee that you want to leave your business to, who's going to keep it running, or if you have a business and you use the income from that business to support disabled beneficiary or to support minor children, you want to make sure that your belt and suspendered in your operating agreement and your will, you need to think about these things now. You can't just leave it up to fate. So again, you want to be proactive, not reactive. So real life examples is what I'm about today. And I'll tell you a story here. I had a young couple come in. They had 3 minor children under the age of 7. They wanted to do their estate plan. We prepared their documents. Everything would go to the wife. If not to the wife, then to the 3 kids in trust. So meaning if something happened to both of them, then it would go to the kids. But otherwise, everything went to the spouse. Now, we drafted the documents, we reviewed the documents, and the clients kept putting off when they were coming in to sign. He was an accountant. It's always busy season. When he was off from busy season, he was on vacation. He didn't want to take care of it. We finally got a call from the wife saying, husband went out jogging and passed away on a jog. Their documents were not signed. He was survived by a wife. He was survived by 3 minor children under the age of 7, I just told you. So the will category doesn't apply, and New York State's will category does apply, meaning it falls under intestacy. I just told you previously, that means that not everything goes to the wife. What actually happened is $50,000 off the top goes to the wife. The balance gets divided 50% to the wife and 50% to the kids. That 50% to the kids gets held in a guardianship, quote unquote. It's not like I just told you in the previous slides about guardianship, but it's held in a guardianship account until they're age 18. And then when they're 18, they can access 1/3 of that 50%. Now I know for a fact that's not what that family wanted, but because they kept putting it off, that is what happened. So it's very important that we plan for while we're alive, we plan for when we're no longer here, and we are proactive instead of reactive. It's not just for people who are rich. It's not just for people who have complicated estates. It's for anybody. If I have minor children, if I have disabled beneficiaries, maybe I am, maybe I don't think I'm rich, but I'm close to the estate tax exemption amounts. Maybe I don't realize, or maybe the estate tax exemption laws are going to change, which they may. I want to plan for that. I want to be proactive. I don't want to be reactive. Moving on. So we've planned for while we're alive in our toolbox. We have our ancillary documents. We planned for when we're, for the later, we have our wills. Now that we have those core estate planning toolbox, those core estate planning documents in our toolbox, we now need to put it all together and make sure that everything works well together. This is leading me to the next mistake. Misunderstanding probate versus non-probate assets. So what does that mean? I may have done my will, but I still may not understand how everything works together. A will only applies to assets in my own individual name at my death. So I like to think of it like this. There are 3 ways my assets can pass when I'm no longer here. The first way is what I'll call by operation of law. So if I have a account and it names Maggie as a joint owner, and if I pass, it now becomes Maggie's account. So we have a joint account, something happens to Karen, it automatically goes to Maggie. If I have a life insurance policy and it names Jane as the beneficiary of the life insurance policy, well, then on my death, Maggie's going to get my joint account and Jane is going to get my life insurance policy, all by operation of law. By virtue of me dying, we had a joint account, we had a named beneficiary. So any accounts that have that, so the named beneficiary, the joint owner, the payable on death, the transfer on death, fall under that category of by operation of law. The second way an asset can pass is under the terms of a trust. So I may create a trust, like I said before, for Medicaid planning purposes, for estate tax planning purposes. Maybe I have I'm worried my family is going to fight at my death because of the distribution of my assets. Whatever the reason is, I've created a trust and I've transferred assets to my trust. So for example, let's say I transferred my house to a trust because I was worried about Medicaid planning. Well, then on my death, wait, let me back up. Let me tell you my trust terms. My trust that I transferred my house to has a provision in there that on my death, any of the trust assets go to XYZ charity. So what happens on my death is Maggie gets my joint account, Jane gets my life insurance policy, and XYZ charity gets all the trust assets. So they get my house. This all happens without taking a look at my will. It automatically happens by virtue of my death. You show a death certificate and that's it. That's what happens. So a joint account, named beneficiary, payable on death, transfer on death, that's the operation of law. I have my trust. If I transfer assets to the trust determines where it goes. The final way my assets go is under the terms of a will. And if I don't have a will, remember New York State writes one for me. That means the will only applies to assets in my own individual name, no joint owner, no named beneficiary, just Karen Birnbaum. That's what my will would apply to. So what's a mistake here is not understanding how everything works together. I have met so many clients who will come in to me, we'll have a meeting, they'll say, I want everything to go to my 3 children. I'm definitely picking on 3 children here today, but I want everything to go to my 3 children. Okay, so let's go through your assets and we'll go through assets number 1. And it has mom named as the owner and the 3 children as beneficiaries. Well, that's great because everything gets divided in 3. And then we'll go further down the list and mom will have a joint account with the eldest son because he lives close and he handles the checks and it's just so much easier. Well, what actually happens, mom, on your passing is that one account goes to the eldest son. It does not get divided in 3. It does not go in accordance with your will. It goes to that eldest son. So it's very important that we sit together as a team. You sit with your attorney, you sit with your accountant, you sit with your financial advisor. You want to make sure that all of your accounts are titled properly, that they have the proper beneficiary designations, and that everything works together. You also want to name successor beneficiaries. So if I name Jane as the beneficiary, but something happens to her, who's next in line? I want that to be consistent with my will. I want it to be consistent with my named beneficiaries. I want it to be consistent with my joint account holders. And how do I do that? I need to work as a team with my planners, with my accountants, my attorney, my advisors, and make sure that everything is titled properly so that the proper outcome comes into play. My final and most important takeaway is, yes, we put our estate planning toolbox together. We have our planning for while we're alive. We have our planning for when we're no longer here. And we were able to put it all together. I still need to look at it. I'm not one and done. I got to look at it. So I may have a change in beneficiaries. Yes, that's an obvious way to remember to look at it if I want to change the beneficiaries. But there may also be a change of laws. So right now, Biden is in office and he's possibly changing the estate tax laws, which I'm not getting into in this, short time we have together. But I probably want to take my documents out and make sure I don't have an estate tax concern. Same is true of Medicaid. Medicaid laws are changing. I want to make sure that my documents are consistent with how they're supposed to be. So I'll typically tell a client you need to review your documents once every 3 years, but at a minimum, I like the 5 Ds. I like to refer to them. Death. Anytime there's a death, whether it's a family member, whether it's a beneficiary, whether it's a friend, whether it's nobody in my documents, it's a good reminder to take my documents out and review them. Whether I'm getting divorced, I definitely want to update my documents. Divorce, definitely change your documents. Definitely look at your beneficiary designations. But it's not only my divorce, it's a child's divorce, it's a beneficiary's divorce, it's a professional divorce. It's any divorce that happens, take your documents out and look at them. Make sure they're consistent with what you want. Disability. So this is a common one. People don't often think about their beneficiaries' disabilities. If somebody is disabled and they're on a specific kind of government programs, inheriting assets will actually kick them off of their programs. If somebody is now deemed disabled, look at your documents. Make sure that what you're giving them is not kicking them off of their programs. So you may want to give them assets in trust versus outright, or various other techniques that you could use. But you definitely want to take your documents out and review them. Descendants. So if there's a new child, a new grandchild, a beneficiary's child, take out your documents, review them. How many times am I sitting with somebody and they'll say, I haven't updated my documents since my 30-year-old was in diapers. Well, lots has changed since then, right? Take your documents out and look at them. Finally, distance. So while you can still name people that are far away, you definitely want to review your documents should somebody move away and make sure it's practical. So I'm talking about an executor role, a trustee role, an agent role. Take out your documents and review them. I will also give you a sixth bonus mistake that I'd like to see everyone avoid, and that's people who don't know what their assets are. So oftentimes I'll have a woman, and I'm picking on females, so I apologize, but it really could be anybody. It's people who don't have any idea of what their assets are, how they're held, or who to even contact to manage that asset. So oftentimes I'll have an elderly client come in whose husband just passed away, and she'll say to me, I don't know anything about my husband's assets. Or I'll have a young couple where the wife is busy in the house and she says, you know what, husband, you take care of it. I don't want to be bothered. Or she's working outside the home and she says, hey, husband, I don't want to be bothered. Or you have the traditional roles where I'm not involved in the finances, you're involved in the finances. And it also comes in the flavor of, I think I know everything, but in reality, I don't really know what I'm talking about. So it is so important to educate yourself as to your finances. Make yourself a list. What are your assets? How are they held? Who are the named beneficiaries, if any? Who are the joint owners, if any? What are the account numbers? What passwords do I need to access them? Who do I call if the account needs to be serviced? What does it mean when something says retirement account? What does it mean when something says an annuity? What does it mean if something says a managed account? Review your terms. Understand this. Don't put yourself in a position where you're not educated. And to that end, I was just talking with a financial advisor that I work with, and she specifically said to me that anytime she has a client that's married and the husband wants to talk to her by himself, she will always say to him, you must have your wife present on that meeting, in that meeting, COVID aside, because she needs to know as well. So don't put yourself in a position where you don't know. It's very important to educate yourself. Take active initiative, learn about whatever you can. And if you don't understand, reach out to your team. Again, that attorney, that accountant, that financial advisor. Get yourself a team. Be proactive rather than reactive. And I will leave this quote for you, is my favorite one, is failing to plan is planning to fail. So be proactive, get your plan in order. And I guess, Maggie, we can open the floor to any questions.
Okay, great. Thank you, Karen. That was amazing. A lot of information in there. If anyone has a question, you can use the Q&A box, or you can also use the chat box. And Karen, the first question for you is asking, can a healthcare proxy make end-of-life decisions also, or do you have to have a living will?
Okay, so the answer, I'm looking, I see, I opened the Q&A.
Okay.
Maybe I won't look, so I can answer everybody. So a healthcare proxy can say whatever you want it to say. The issue with a healthcare proxy is that it comes out in routine situations and it comes out in more dire, quote unquote, situations. So take a healthcare proxy that says, I don't want to be put on a ventilator, and then throw a pandemic into the mix, right? And during the pandemic, especially in the beginning, ventilators were used as a treatment, but ventilators were hard to come by. And I'm a doctor and I only have one ventilator and I have two patients, both unconscious, and I'm looking at their healthcare proxies. And one healthcare proxy says, I don't want to be put on a ventilator. And the other healthcare proxy just says, my agent knows my wishes. Who is the ventilator actually going to go to? Not the one who necessarily needs it the most, but it's going to go to the one who just says, my agent knows my wishes. So I don't personally or professionally like to put those end of life decisions in a healthcare proxy because I don't want it to be misread. I don't want the circumstances to dictate what's going to happen. I want my agent to know my wishes and I want my agent to carry those wishes out. That being said, New York State does require clear and convincing evidence for somebody to make those end of life decisions for you. And let me just clarify, I'm not talking about assisted suicide. New York State is not an assisted suicide state. However, the end of life decisions, you need clear and convincing evidence. So I put the clear and convincing evidence in the living will. My healthcare proxy says my agent knows my wishes. Should it become end of life decisions, now my living will comes out. My healthcare agent brings my living will, says these are my end of life, these are Karen's end of life wishes, and then it happens that way. So there, while it can go in there, my preference is not to put it in there.
Okay, great. Thank you, Karen. Next question, and I see we do have a lot of questions, so we'll try and get to as many as we can, and we'll also share Karen's contact information as well. The next question is asking if you could speak to if you can make two people a healthcare proxy or a power of attorney, such as your spouse and sibling. What happens if they disagree?
Very, very good question. So I debated going back and forth as to how much detail I should get into, because really I could talk about each one of these items probably for all day. So the healthcare proxy, I can only appoint one person to make a healthcare decision at a time. Why? As you just said, right? People may not get along. What doctor or what institution wants to deal with people who don't get along? It's as if you don't have a healthcare proxy, essentially. So I can only name one person to act at a time on my healthcare proxy, but I can name as many successors as I want. So if one person isn't acting or is far away or is deceased or whatever, the next one can come into play. So that's one person at a time. The power of attorney, I can appoint multiple people. So let's say I have children. I have the three, I keep talking about the three children, and I don't want to hurt anybody's feelings. So I'll say, I'll put them all there. I could do that. It's really a case specific question because I don't want to appoint people who will typically not get along. Granted, I can't provide for every situation, but oftentimes if I have three, I'll say majority rules. The issue is it's a powerful document and more people feel comfortable having more than one agent named, because if you give one agent the ability to access your assets, your accounts, really they can just go in and clean you out. Whereas if you have two people, well, they're checks and balances on each other. So I imagine, a good angel and the devil on the side, right? Who's doing what? The problem is if they disagree. So you can put provisions in there. If they disagree, you can add that to the modification section of your power of attorney. You can also give them the authority to act independently. So that means that even though you're naming two people, they can each take care of something on their own. So for example, if I have a family where everyone gets along, there are two kids, one lives in California and one lives in New York, well, I'll give them the authority to act independently because odds are the New York child is going to be taking care of things much more frequently than the child in California. So I hope that speaks to your question.
Thank you, Karen. The next one is asking if you can explain the difference between a regular will and a living will.
Sure. So a living will specifically applies to end of life decisions. Um, that's it. That's all the living will applies to. Um, a last will and testament is what applies for your assets. So they're different. It sometimes gets thrown around together because they both sound like will. The living will is about your life. The last will and testament is what happens to your assets.
Thanks, Karen. Next question. Is it advisable to have an attorney be the executor of your will, or can you choose your children to be co-executors? Is it very difficult for them to handle if they have no legal experience?
I'm sorry, can you, you asked if an attorney has to be one. So no, you don't need an attorney to act as your executor. There are reasons why you should, and there are reasons why you should not. Most people, if they have children or they have a spouse or they have a sibling or they have a niece or nephew, most people will name their family members. The job of executor is simply following rules. So what does an executor do? The executor finds the original will. I don't know what finds means. It could mean that it's in a safe deposit box, which it shouldn't be, but maybe it's an attorney's office and they call the attorney and say, I need the original will. But that's the extent of what they do. Then they file the will in the surrogate's court with the help of an attorney or on their own. Then they get appointed by the court. At that point, they then collect the assets. So that means they go to the financial institutions and they say, hey, listen, Chase, I'm appointed the executor of my mom's estate. So Chase will now deal with them. Chase gives them a check made out to the estate of Karen Birnbaum. Now my executor goes to Chase and opens a estate account that says estate of Karen Birnbaum. So the check turns from Karen Birnbaum into the estate of Karen Birnbaum. And then the executor follows along the will. Because I've done a will, I laid out where I want my assets go. So I said, I want a third to go to daughter A, a third to go to daughter B. Whatever it is that I want, now the executor writes out a check. 50% to daughter A, 50% to daughter B. So what I say about an executor is they need to be responsible and they need to be a rule follower. So there are obviously certain things that disqualify you from being an executor, like being a felon, like being a minor, like being incapacitated. But if you can appoint your family members, there's no reason not to. Additionally, I will just throw out there that there are fiduciary commissions. So that means you get a fee for acting as the executor or as a trustee. Typically, if I'm appointing, and I say the proverbial if I'm appointing my family as a fiduciary, as that executor or trustee, I am not going to allow them to take commissions. I won't get into why, but it's really not beneficial for them. Versus if I appoint an attorney, well, then they're entitled to commissions and they're entitled to legal fees for acting as an attorney. So it's definitely something you need to weigh the pros and cons of.
All right, thank you. Thank you for explaining that. Next question is asking if you can go over who should be on your team.
Sure. So your team, much like the estate planning toolbox, is relative to you. So like in that toolbox, in that initial slide, I told you maybe you want to have a trust, maybe you don't. Who is on your team? You definitely want an accountant, an attorney, and a financial advisor. That's my core team. Now, if I have real estate that I'm selling, I want my real estate broker. If I have a life insurance, disability insurance that I want to look into, long-term care insurance that I want to look into, my financial advisor may not be that right person. Well, then I'll want an insurance advisor on my team as well. Maybe I want a title company on my team. Maybe I want a medical professional on my team. So it really is case specific, but you definitely want that core group. You want your attorney, your accountant, and your financial advisor.
Okay, thank you, Karen. Question here is asking, what do you think about doing a will using an online service?
I always answer this question like this. You don't know what you don't know. So it is definitely convenience. I'm a working mother and a wife, and I get it. It's so much easier to just take care of it myself, put in the information, but I don't know what I don't know. So for example, I had a client who came to me. His father had passed away. And he brought me in a will that his father had prepared using an online service, to remain nameless because there are a few out now. And he was 26 and his sister was 16 in high school. and everything went 50-50 to son and daughter. No guardianship provisions. Mom was not in the picture. And as the story came out, father had a booming business, and the son, the 26-year-old, was in business with the father. And the goal, according to what the son told me, was that the business was really supposed to go to the son, and the son was supposed to use the business to provide for his minor sister. But the will that he put together had everything going 50-50. So what in actuality happened is father's booming business went 50% to the 26-year-old and 50% to a 16-year-old who definitely had no idea what she was doing, maybe didn't want to be part of the business, and there were no guardianship provisions in place. So you don't know what you don't know. He thought he was just, putting together a will. It was quick. It was easy. He knew he was sick and was just easier to take care of it that way. But he really ended up hurting his family in a way that he shouldn't have because he just didn't know. So I see why you would want to use a legal, what's it called? Online service. I get it. I don't usually recommend it at all, ever, for anything.
Okay, thanks, Karen. Next question here is asking the importance of disability insurance if you're not working.
I would say the importance of disability insurance if you're not working may be non-existent, but you have to take into account your life. So if you're relying on somebody else's income, if something happens to that person you're relying on, where are you getting your income from? Where are your bills being paid from? What assets are you going to have? So it's definitely something you would discuss with your team, maybe worth a phone call to an insurance advisor. But that being said, you probably don't need it. But again, I'm not, like I said in the beginning, I'm not a disclaimer. I'm not an insurance advisor, so I wouldn't necessarily send you in that direction.
Mm-hmm. Okay, thank you. Question here asking about what happens to debts like student loans.
Good question. So if you have assets, your debts will likely need to be repaid before your assets get distributed to your family members. So what happens is you file your will in or your family, your executor files your will in surrogate's court. There's a 7-month period that creditors have to come forward in New York State saying, Karen owed us this money. Karen owes money for law school loans. She owes us $20,000. They file that claim against the estate. Then you have my credit card coming forward and saying, Karen owes Chase $20,000. So now what happens is before my assets can actually get distributed, I've got to my estate has to give the $20,000 to my law school loans, and they have to give the $20,000 to the credit card company. Now, there's always wiggle room. So once a claim against the estate is filed, your executor can call up those companies and say, listen, she only had $20,000 in her name. So we're not paying you $20,000 because she has other creditors. Or she has a minor child and it really should go there. And then you have a conversation with somebody on the other side, but they don't just disappear because you're deceased. There are obviously exceptions to the rule that I'm talking about. Most often what I see is that they're negotiable. In my experience, your debts are negotiable at your death. Trying to think if there's something else to say here. So the creditors have that 7-month period to come forward. That's not to say they can't come forward after 7 months, but what happens is, as the executor, remember I said you're in charge of collecting the assets and then distributing that asset. During that 7-month period, I probably want to hold those estate assets in an estate account. I want to keep it closed vested because maybe somebody's going to maybe a creditor is going to come forward and file a claim against the estate. After that 7-month period, I can distribute the assets out. That doesn't stop the creditor from coming 9 months after, right? But I've already distributed the assets out. So the creditor now has to try to go and get the money back from the beneficiaries, which I haven't seen them do. This actually just happened in a state that I'm dealing with, and a creditor came forward 9 months after, and too bad, so sad, the assets are distributed. So that sucks for the, pardon my French, that sucks for the creditor. So they do, though, have the opportunity to come forward and be reimbursed.
Okay. Karen, this next question is asking how often should we review our healthcare proxy?
So I would have put that same slide up if I could go back. But You definitely want to review that anytime any of the 5 Ds happen. So death, disability, divorce, descendants, and distance. So if somebody moves, if somebody gets divorced, maybe I appointed a son-in-law because he's the doctor in the family, and then my daughter gets divorced from him. I don't want to name him. Maybe somebody lives next door to me, but then moved to Hawaii. I don't want to name them. Maybe I do, maybe I don't, but I want to take out the document and review it. As my children reach age of majority, maybe I want to update my documents and I don't want to name my sibling. Maybe I want to name my daughter. Maybe I want to name a personal friend and then we've had a falling out. So you really need to let the life circumstances guide you, but any life circumstance, take those documents out, whether it's a healthcare proxy, whether it's a power of attorney, whether it's a will, take it out, review it.
Great. Okay. Thank you. Karen, we have a few more questions for you if you have a little bit more time.
Yeah, we have a few more time.
Okay, this question says, my daughters are 14 and 18. Can I create a trust for each daughter to receive assets from my trust if I pass away? Note, I am not married.
Yes. So what you could have a few options. You could put trusts in your will. So you would put in your will, I'm assuming 50% to one daughter and 50% to the other daughter. But instead of going outright to them, so instead of daughter A getting a check on mom's death and daughter B getting a check on mom's death, you put it in a trust for their benefit. And that trust gets set up under the terms of your will. Or alternatively, if it makes sense for you now, you could transfer your assets to a trust now. And then on your passing, everything just goes to them in accordance with the trust. So you can even set up trusts under that trust. It really is so case specific, whether you would want to create a trust now, and if so, what trust you would create, or whether you just create a will that has those what's called testamentary trusts in it. So trusts set up under your will are called testamentary trusts. But that's definitely something you can do, and definitely something you should do as a single woman, because God forbid something happened to you now, 50% is going to your 14-year-old and 50% is going to your 18-year-old. And I don't know what your assets are, but I have a 14-year-old and I definitely don't think that she knows what to do with $10, let alone 100 or increase that amount. So you could definitely do some sort of trust planning for them.
Okay, thank you.
Yeah.
This question here says, does a will supersede a trust or vice versa?
Okay, so this is back to my the 3 ways my assets can pass. So remember, the first one is by operation of law. The second is under the terms of a trust. So if I have created a trust during my lifetime and I have put assets in the trust, so it's not simply, writing a trust document. I have to actually physically transfer assets to it. So whether that means filling out forms with a bank or doing a deed transfer, transferring my property into the trust, I have to do something to make it happen. Then the trust determines where that asset will go. So I have my operation of law, automatically happens. My will doesn't apply. I have assets in a trust. The trust determines where the assets go. My will doesn't apply. The will only applies to assets in my own individual name. So Karen Birnbaum, no joint owner, no named beneficiary, no payable on death, no transfer on death, not in a trust. That's when the will applies. So it could be, after looking at your whole picture of assets, maybe you don't need a will. Maybe you have one account and it names your 2 daughters as your beneficiaries, and that's fine. But maybe you do need a will. Maybe you don't really want to name the daughters outright as beneficiaries. Maybe you wanted to go in trust for their benefit, like the previous question suggested. Maybe you have a more complicated estate plan, but the trust does supersede the will, provided it's funded, right? It has to have assets in it, and the trust applies to the assets in the trust name. So it doesn't apply to assets outside the trust, only to the trust assets.
Okay, thanks for explaining that. This question says, where do you suggest we keep these documents? Safety deposit box, in the cloud, elsewhere?
So such a good question. No safe deposit boxes. I am not a proponent of them for anything. Why? On your death, your box gets sealed. If I put a joint owner on, even if I'm deceased, the bank may lock my box. And how do I unlock a box? I have to go to the surrogate's court and I have to do a separate petition to open the safe deposit box. Then once they go through the safe deposit box, they have to do an inventory of the assets. And at that point, then I get to file my probate proceeding. And just a quick story here is I had a client who the family didn't think she had a will, but she had a safe deposit box. And on the petition, where it's set, where the family petitions the court to be appointed in charge of her estate, it says, I have searched the will, I've searched the safe deposit box, and there is no will. So you can't just say I've searched the safe deposit box without actually searching it. So we had to file a petition to search the safe deposit box, and then COVID happened. So for a year, the family could not get into the bank to look at the safe deposit box. So the whole probate process was delayed for a whole year because of the safe deposit box. There are exceptions to the rule. There are financial institutions that will allow family members, if there's a joint owner or whatnot, to open that safe deposit box. But as a general rule, the box gets locked on death, regardless of whether they're joint owners or not. So my personal preference is not to keep them in a safe deposit box. I recommend keeping it in a fireproof box in your home. So whether that's something that's small, whether it's something that's big, or you have the option of leaving it with your attorney. Leaving it with your attorney does not mean it's your attorney's property. It's a service that your attorney would provide for safekeeping. It doesn't mean that on your passing, your family needed to use that attorney. It's really just for safekeeping. Obviously, every attorney works differently. That's how I work. So I don't recommend safety deposit boxes. I do recommend a fireproof safe in the house. If you don't feel comfortable with that, or you don't have room for that, or whatever, then I would recommend leaving it with the attorney.
Okay, thanks for explaining that. Here's a question that's saying, before we can make an appointment with you, can we print some of these out online and fill them out? Are these valid if we have them notarized?
The short answer is yes, probably. You can Google it. I have not done it recently. But to that, I'll say the same thing, like I said, for the online services. You don't know what you don't know. So I just gave you information. Yes, you could only appoint one healthcare proxy at a time, not to put such detail in there, leave it open-ended. But the fact of the matter is you don't know what you don't know. You don't know how it needs to be executed. Yes, you can probably look that up as well. I haven't looked at it recently. It could work out. It could also not work out. So, good luck.
Okay, thanks, Karen. How does a DNR relate to a healthcare proxy or a living will?
It goes hand in hand with them. So the DNR is do not resuscitate. So I would just hope, and I would recommend that it's consistent with what you have told your agent you want in the event you couldn't make a decision for yourself. So definitely, if you're able to sign a DNR and you have one, that's great.
Okay. Karen, we had some questions asking about where you're located and if you're available for consultation, if there's a cost for consultation. So I want to give you the chance to kind of speak more about your offerings.
So right now I am located in Melville on Long Island. I do, though, work in the metro area, meaning I have New York clients, New York City, Manhattan clients. I have Bronx, Kings, Nassau, Suffolk, Queens. So I have some as far as Westchester, Rockland County. So I do see clients all over, especially now with COVID. There's a lot of virtual meetings happening. I do typically charge for a consultation, but I will extend a courtesy to any of the participants today that I won't charge a consultation fee for that. And typically how it would work is with the consultation fee, just for reference, if you should refer somebody else, is that any money spent on the consultation gets deducted from the total amount should I be retained later on. But again, I'm going to extend that courtesy to all of the participants that there would be no consultation.
Thank you so much, Karen. We will be sure to put that in our follow-up email so everyone has that information. And I wanted to share a message here in the chat that says, thank you, Karen, very informative, and thank you for encouraging women to get in this place and empower themselves with information. Thank you also for bringing up disability insurance. I just lost my job and it occurred to me I no longer have this through my employer and need to call my insurance agent.
I'm so sorry to hear that. And if I could help you or guide you to the right person, I'm happy to help.
Mm-hmm. Thank you, Karen. And some more messages are coming in. Thank you. Wonderful session. Thanks so much. Thank you for your time, Karen. This was a wonderful workshop. So Karen, with that, I wanted to thank you so much for presenting today and clearly explaining a lot of information for everyone today. And thank you so much for taking the time to answer all of our questions as well.
Sure. Thank you so much for having me. It was a pleasure. And please let me know how I can help.
Great. Thank you so much. Thanks everyone for joining us. We'll send a follow-up email soon. Thanks again, Karen.
Bye.
Bye-bye.